Due to over-exploitation of whales during the period between the two world wars, efforts began being made to regulate whaling in 1931 and again in 1937. While these attempts were unsuccessful, they lay the foundations for the subsequent 1946 International Convention for the Regulation of Whaling. Australia played a major role in the formulation of the ICRW and was one of the first states to ratify the treaty in 1948. Japan subsequently ratified the treaty in 1951. In 1982, the International Whaling Commission, established under the ICRW, held a meeting whereby they decided to impose a temporary prohibition on all commercial whaling, referred to as the Moratorium on Commercial Whaling. It came into effect for the 1985 to 1986 whaling season. Subsequently, in 1994, the ICW established the Southern Ocean Whale Sanctuary, within which there was a total prohibition on commercial whaling. Notably, Japan opposed the establishment of the sanctuary and unsuccessfully proposed its removal in 2004. The purpose of the convention was to regulate the whaling industry in such a way as to provide for the proper conservation of whale stocks and make possible the orderly development of the whaling industry. At its inception, the convention did not purport to outlaw whaling and did not propose to ban commercial whaling either. Rather, it was focused on finding a balance between the economic benefits of whaling and the risk of overexploitation of this natural resource. The convention included the primary document, as well as the schedule to the convention, which sets out the relevant information regarding catch limits for different species of whale, area limits, and other restrictions on whaling that are imposed so as to achieve the overall purpose of the convention. Article 8 of the convention provides contracting governments with the authority to issue special permits to its nationals, permitting them to kill, take, and treat whales for the purposes of scientific research. The killing, taking, and treating of whales pursuant to a special permit is exempt from the other provisions of the convention. In 2010, Australia commenced proceedings against Japan for Japan's continued pursuit of a large-scale program of whaling under the JAPA 2 program. Australia alleged that Japan was in breach of its obligations under the ICRW, as well as its other international obligations for the preservation of marine mammals and the marine environment. Australia alleged that the JAPA 2 program was not a program for the purposes of scientific research, and therefore by implementing and conducting the program, Japan was in breach of a number of provisions of the schedule to the ICRW, including the obligation to respect the moratorium on commercial whaling, the obligation not to undertake commercial whaling of fin whales in a Southern Ocean sanctuary, the obligation to observe the moratorium on the taking, killing, or treating of whales other than minke whales by factory ships or whale catchers attached to factory ships, and that Japan had failed to comply with the procedural requirements for proposing the granting of special permits. Japan contested all of the allegations put forward by Australia on the basis that it had validly issued special permits under Article 8 of the ICRW, and thus all activities undertaken pursuant to that program were exempt from the provisions of the convention and its schedule. Japan also contested the jurisdiction of the ICJ in determining this matter.
The three key issues before the court were the jurisdiction of the court, the interpretation of Article 8, and whether Japan had breached the provisions of the convention. Jurisdiction of the ICJ was a key issue within the proceedings between Australia and Japan. Both countries had already signed and ratified the International Convention, and therefore both were willingly bound. Australia brought their action against Japan through a declaration under the International Court of Justice Statute, Article 36, Paragraph 2b, in recognizing that state parties, many at any time they recognize as compulsory ipso facto and without special agreement, the jurisdiction of the court in all legal disputes concerning, as is included in Paragraph A, the interpretation of a treaty. However, Australia's claim to the ICJ excluded disputes relating to the delimitation of maritime zones, including the territorial sea, the exclusive economic zone, and the continental shelf, or relating to the exploitation of disputed areas of or adjacent to any such maritime zone. Or simply put, Australia's claim expressly excludes from the court's jurisdiction any issues relating to boundaries over maritime areas. Japan's argument against the court's jurisdiction was in Australia's reservation of subsection B. Japan believed Australia's action against the JARPA 2 program was actually a delimitation or boundaries dispute, as they are exploiting a resource, the whales, in an area near the Antarctic that Australia claimed sovereignty over. Japan did not recognize the sovereign claim of Australia and believed that the area of exploitation was part of the high seas. The court decided that they, in fact, had jurisdiction, agreeing with Australia's arguments. Paragraph 2b could only be triggered by an overlapping maritime claim which Japan simply did not have. The dispute did not have any issues regarding maritime delimitation as they lacked relevance in the action and Japan had no claim over those waters. Therefore, Australia's reservation could not be applied. The Statute of the International Court of Justice has provisions which have significance in determining the court's jurisdiction and powers in determining Australia's action against Japan. As mentioned before, Article 36 gives jurisdiction to the court to interpret treaties, including the International Convention for the Regulation of Whaling. Treaties are considered as the main source of international law among states that willingly bind themselves to them. Article 38 provides that the sources of law that are to be considered by the court when making their decisions include international covenants, generally accepted legal practice, general legal practice, and any applicable judicial decisions or teachings. The main cause of tension of the case was in the interpretation of Article 8, Paragraph 1 of the International Convention for the Regulation of Whaling. Australia urged the court to adopt an objective standard in determining whether Japan had violated their obligations under the ICRW. They put forth four key principles identified by Mr. Mangle, their expert, which was argued to be essential in defining scientific research. Australia also argued, using IWC Resolutions 1986-2 and 1995-9, that lethal methods should only be permissible where non-lethal alternatives, including the analysis of existing data, were incapable of achieving research objectives. Australia accused Japan of continuing their commercial whaling industry through JARPA 2's guise of scientific research. Japan offered no alternative to Mr. Mangle's four elements, but cautioned the court against essentially letting an expert define a treaty term. Whilst Japan initially pushed the argument that the court was limited in reviewing the validity in granting the JARPA 2 permits, as the issuing state was the most competent in determining if a research program met the criteria under Article 8, they shifted to agree with Australia and New Zealand in that the court should adopt an objective standard in reviewing the permits. The International Court of Justice determined the phrase for the purposes of scientific research as a cumulative term composed of two elements, scientific research and for the purposes of. The majority interpreted Article 8 in light of the Convention's object and purpose, which regards the conservation and protection of all whale species to ensure sustainable exploitation. They noted that programs under the article should contribute to scientific knowledge, which was not limited to the conservation or management of whale stocks, but also alternative knowledge, including the conservation or management of ecosystems dependent on whale stocks, or other matters related to research. The court determined that whether a special permit falls under the exception is not based on the state's perception, but an objective standard. Firstly, the court refused to define scientific research, the initial element, merely noting that not all four of Mr. Mangle's elements are required, and how both experts agreed on the presence of a hypothesis, but they disagreed on the required specificity. Additionally, IWC guidelines and resolutions were not legally binding due to the absence of consensus, and explicitly Japan's refusal to vote in their favor. However, Japan was still bound to a duty of cooperation to the bodies under the ICRW to consider the feasibility of non-lethal methods. The objective standard to be decided was whether JARPA 2's design and implementation were reasonable in achieving the program's research objectives, without delving into the scientific merit and focusing on the identified elements. Ultimately, the court concluded that JARPA 2's design and implementation was not reasonable in achieving research objectives, as it pertains to their use of lethal methods. This was despite the court ruling that the presence of lethal sampling did not automatically violate the objective standard of reasonability, and the broad scientific research element was satisfied by the program. Several factors led to this conclusion, as I will set out. The court found the decision making in JARPA 2 in regard to the use of lethal methods was troubling, as the program significantly raised their lethal target sample size from the first JARPA program, and yet Japan had not sufficiently convinced the court that the program had considered using non lethal methods. This is particularly problematic where the IWC guidelines mandated that consideration. Japan implied that the consideration was already made by claiming their use of lethal methods were only to the most necessary extent, and the significant technological advances in the time frame between the two programs warranted that consideration. As aforementioned, the scale of lethal sampling grew immensely between the JARPA programs. Despite remaining consistent in subjects, objectives, and methods, the court struggled to reconcile the conflicting points that the lethal sampling is justified due to JARPA 2's growth in ambition and sophistication, but yet shares significant similarities with JARPA 1. The conflicting points in JARPA 2's premature launch, which occurred before the scientific committee's review of JARPA 1 was released, aggravates the notion that the increase of scale is not due to scientific reasoning. The significant disparity in target sample sizes and actual collected sample sizes for all three whale species also disfavored Japan's case by aggravating the concern that JARPA 2 sample sizes were more than necessary, therefore unreasonable, in achieving the program's research objectives. Japan refused to adjust their targets, citing that the discrepancies would not adversely affect the program, as the time frame was extendable or that less accurate results were acceptable, despite the set 6 and 12-year research period set. The discrepancy also highlights the inconsistency between Japan's continued justification of their target sample size through their research objectives regarding the Antarctic ecosystem and multi-species competition, where they only essentially collected samples from one species. The methodology used was highly questionable and lacking transparency as to how the target sample sizes were exactly reached. The sample sizes for the fin and humpback whales were strikingly lower compared to the number in the research plan that was needed annually to detect the particular change identified in the research objective. And there's no explanation whether that difference was accepted due to a decision to accept less accurate data or an adjustment in the rate of change thought to be analyzed. A glaring factor disfavoring Japan was Mr. Mangel's conclusion that implied the unreasonability of the sample size for minke whales, as a smaller sample size could produce nearly the same level of accuracy, to which Japan failed to respond. Other deciding factors included the court favoring a limited time frame with actual targets which would have showed progression in completing the research objectives, as opposed to an open-ended time frame which merely stopped at 6 or 12-year periods for review with no actual end in sight. The court also questioned the seemingly lack of evidence relating to cooperation with other research and scientific programs. Although Mr. Wallow had a strong point that international programs would be hesitant to work with JARPA 2 in light of the controversy surrounding its use of lethal methods, the court was not satisfied by that explanation, as the subject matter of the research was alluring in researching Antarctic ecosystems and the competition between different species of whales. The court also cited not only the lack of cooperation with Japanese institutions, but also the fact that the evidence provided regarding some cooperation with Japanese institutions was related to JARPA 1, not JARPA 2. The court also expected significantly more scientific output from a program that had been operating for nearly 9 years at that point and killed a significant amount of minke whales. Japan provided 8 papers, only 2 of which were peer reviewed, and lacked any correlation with the program's research objectives. 6 whole papers had minimal, if any, connection to actual scientific output produced by the program, mostly focusing on the cruise and practicality of the proposed program itself. The lack of scientific output concerned the court and created more doubts as to the true purposes of the program. As the court found that JARPA 2's design and implementation were not reasonable in achieving the research objectives in relation to lethal methods, the court found that JARPA 2 was not a program for the purposes of scientific research under Article 8. The four dissenting judgments shared commonality in their disagreements, with the first shared factor being the court's adoption of an objective standard to determine the suitability of the JARPA 2 permits under Article 8 and the reasonable standard comparing the design and implementation against completion of the research objectives. Judges Owada, Abraham, Benone, and Yusuf all found the court to be operating outside of its capacity. Judge Owada specifically interpreted the ICRW as creating a regulatory regime with sufficient regulatory bodies, the Scientific Committee, and the International Whaling Commission, that were more capable and appropriate to determine whether JARPA 2 was a program for the purposes of scientific research. Judges Abraham, Benone, and Yusuf accused the court of inappropriately exercising the functions of the Scientific Committee as a court of law. Judges Owada and Yusuf also criticized the adoption of an objective standard which lacked any actual grounding in the treaty provisions and failing to provide an explanation. Another common aspect among dissenting judgments were the criticism towards the court's refusal to adopt the good faith test. Judges Owada, Abraham, and Zhu, in her separate opinion, criticized the majority's decision not to incorporate a presumption of good faith on Japan, which would have required that Australia produce significant evidence to rebut that presumption to prove the JARPA 2 permits violated the treaty provisions. Nicole Strain discussed how a good faith test would have favored Japan, as the court would have merely reviewed the legitimacy of Japan's process in granting the permits. Judge Abraham also detailed how Australia should have carried a greater burden of proof in requiring to prove Japan had masked a commercial whaling operation under the JARPA 2 banner by proving the non existent relationship between the objectives and methods, and that the sample size were massively excessive in achieving the research objectives. The dissenting judges also criticized how the burden of proof seemingly shifted from Australia to Japan. Owada and Abraham agreed that Australia, as the applicant, needed to bear the burden of proof in having to produce sufficient evidence that JARPA 2's lethal intake was unreasonable in achieving the research objectives. Instead, it seemed all across the court's deciding factors, it was Japan who needed to prove the reasonability of their decision making, choices of sample sizes, methodology, time frame, and other factors. They were constantly asked to produce the evidence as opposed to their accuser. Three judges found JARPA 2 to meet that reasonability criteria, as Judge Owada cited the Scientific Committee and the IWC Intersessional Workshop reports endorsements for the scientific data produced by the program. Judges Abraham and Yusuf both agreed Australia failed to meet the standard of proof by producing insufficient evidence. The former argued Australia's proof merely amounted to doubts and concerns, and the latter cited the lack of criticism by the Scientific Committee's review of the program and the recommendation regarding the data's usefulness, which were collected by both programs. Beyond the majority's judgment and the main dissenting opinions, Judge Concado Trindades' separate opinion is particularly notable in addressing customary international law. Australia and New Zealand highlighted a significant shift in international law that has continually developed a more conservation based approach, using the prevention and precautionary principles which they used to argue for a strict and stringent interpretation of Article 8. Although the court does not address this issue, Judge Concado Trindade not only acknowledges their arguments but supports the notion that the ICRW should be interpreted in the context of other similar international environmental treaties and conventions that commonly employ those principles to promote conservation. He cites the growing presence of the precautionary principle in international law and the significance of all three parties acknowledging the principle. The precautionary principle in the environmental context was defined under the Rio Convention, which essentially states that threats of significant harm or irreversible damage should be met with precautionary measures despite the lack of scientific certainty, which entails a strict interpretation of Article 8 to ensure that the harm to whale stocks were minimized unless there were contrary evidence. The discussion by Judge Concado Trindade and the arguments by the three parties indicate an addition to the mounting body of evidence that might lead to the potential creation of customary international law, focused on the aforementioned principles, as they provide evidence of opinio juris and the potential for state practice. Although the ICJ have seemingly neglected applying the conservation approach, the growing body of law indicates that they cannot ignore it forever.
In its judgment, the ICJ delivered the following decisions. Firstly, that the court had jurisdiction to hear the dispute. Secondly, that the special permits granted by Japan under the JARPA 2 program did not fall within the provisions of Article 8 of the Convention. It followed then that the court found that Japan was not in conformity with various provisions of the schedule to the convention, which Australia had alleged they had breached, except for the alleged breach of paragraph 30, where the court was satisfied that Japan had complied with the procedural requirements set out therein. Finally, the court gave relief that Japan was to revoke all special permits granted under the JAPA 2 program and were prohibited from issuing any further special permits under that program. Some of the key takeaways from this case include the nature of the ICJ's compulsory jurisdiction under Article 36 of the ICJ statute, the court's use of the standard of review methodology when reviewing the JAPA 2 program and the special permits made under it, and the nature of declarations set down by the IWC as an international organisation. The court's judgment in this case was concerned specifically with the special permits granted under the JAPA 2 program. It did not outright prevent Japan from whaling, nor did it prevent Japan from issuing further special permits under a new program. This was reflected in Japan's response, where Japan discontinued the JAPA 2 program and subsequently proposed and recommenced scientific whaling under the new NUREP-A program in late 2014 to early 2015. Subsequent to starting the NUREP-A program, Japan in October 2015 made a declaration that it no longer submits to the compulsory jurisdiction of the ICJ on matters of research, conservation, management, or exploitation of living resources of the sea, thus preventing any future actions being brought before the ICJ on matters related to Japan's whaling, whether under their new scientific program or otherwise. Ultimately, once Japan was no longer able to carry out its desired whaling goals within the scope of the treaty, or it became too onerous to do so, Japan issued its notice of withdrawal from the ICRW in late 2018 and formally withdrew from the treaty on 30 June 2019. And in July 2019, Japan recommenced commercial whaling. This highlights the limits of the court's power in international disputes, as well as the difficulties with enforcing the changing societal views on environmental matters against states who do not wish to be inhibited. As discussed above, the ICJ in this case adopted a unique method for interpreting the convention by establishing a standard of review the court would use when interpreting whether Japan's special permits were for the purposes of scientific research. The standard was an objective two-part test, and interestingly, the court put the burden of proof on Japan to establish the scientific merits of the changes between the JAPA and JAPA 2 program, in order to prove that the program's design was reasonable and for a scientific purpose. As mentioned, the court was unconvinced of the necessity of the jump in sample sizes between JAPA and JAPA 2, and found that the sample sizes of fin and humpback whales were too small to provide the necessary information required to pursue the objectives of the JAPA 2 program. Additionally, the program could have been adjusted to achieve a far smaller sample size, and Japan failed to explain why this was not done. Also, there was evidence that Japan gave little consideration to the possibility of achieving similar scientific results by using non-lethal methods. Some legal commentary since the decision has praised the court's use of this standard of review procedure and its value as a method of settling environmental disputes moving forward. This methodology allows the ICJ to pass judgment on what might otherwise be contentious areas of dispute among the scientific community without overstepping their expertise as a court of law and not a scientific body. The court also dealt briefly with the legal significance of recommendations set down by the International Whaling Commission. Generally, recommendations of an international organisation established under a treaty are considered soft law and not legally binding on the parties to the treaty. Due to Japan's non-concurrence with a number of IWC recommendations, they could not be deemed subsequent agreements between the parties when interpreting Article 8 of the Convention. The court acknowledged that recommendations of the IWC are not legally binding, but nevertheless may be relevant to the interpretation of the Convention and can put an emphasis on one or another objective pursued by the Convention. They cannot, however, alter its object and purpose. In any event, the court found and Japan accepted that it is under an obligation to give due consideration to any recommendations made, including the resolutions and guidelines calling on states to consider whether research objectives can be achieved using non-lethal methods. This shows that while recommendations and guidelines are not legally binding, states to a treaty are expected to give them due consideration as part of cooperating towards a joint objective and acting in good faith under a treaty.